Good morning, everyone, and welcome to our first Gough Square Live of 2018. Today, I'm joined by Jonathan Goulding, and we're going to be talking about disclosure in criminal cases. This topic actually arises as a result of a suggestion by one of our viewers, and for good reason. Disclosure is an important issue for prosecuting authorities, as it's one of a small number of areas in which what might often seem like a technical breach can cause an otherwise evidentially strong case to be dismissed outright. Even in the best case scenarios, mistakes in disclosure can lead to easy points for the defence and can cause costs to run up as a result of increased applications and arguments. So today we hope to be able to take a look at a few key areas so you'll be confident about making disclosure decisions and can recognise and avoid some of the common traps in this area. As ever, we will be running our live chat, so feel free to get involved and we'll be answering your questions at the very end as usual. But for now, over to you, Jonathan.
Well, thank you, Michael. Disclosure is perhaps the single most important issue in criminal cases. The fundamental requirement is that fairness requires full disclosure by the prosecution of all material in its possession that weakens its case or strengthens that of the defence. Failures in that disclosure means that the basic right of an accused to a fair trial is undermined. Disclosure in criminal cases is so important that it has been enshrined as a duty in Part 1 of the Criminal Procedure and Investigations Act 1996, the CPIA. Proper and scrupulous application of the disclosure regime set out in the CPIA will ensure compatibility with the right to a fair trial. Please could you put up slide 1, where we will consider the initial duty of disclosure. The initial duty of disclosure is set out in section 3(1)(a) of the CPIA. It is designed to ensure that there is a fair disclosure of material which may be relevant to an investigation and which does not form part of the prosecution case. Section 3, subsection 1(a) provides that the prosecutor must disclose to the accused any prosecution material which has not previously been disclosed to the accused and which might reasonably be considered capable of undermining the case for the prosecution against the accused or of assisting the case of the accused. Section 3, subsection 1(b) of the CPIA provides that if there is no such material, the prosecution must give to the accused a written statement saying that there is no such material of a description mentioned in section 3, subsection 1(a). So how should a prosecutor go about the initial disclosure exercise? Well, it must properly review the material in its possession and draw up detailed and proper schedules. It is often said a prosecutor must not make wholesale disclosure in order to going through the disclosure exercise set out in the CPIA. A proper review is necessary, applying the section 3(1)(a) test scrupulously and analysing the facts the prosecution have to establish and the grounds on which allegations are resisted. What material might reasonably be considered capable of undermining the case for the prosecution or of assisting the case for the accused? First, prosecutors should only be expected to anticipate what material might weaken their case or assist the defence on the basis of the information available to them at the time of the disclosure decision. This would usually include information obtained during interviews under caution or that might have been revealed in other representations made by the accused. Secondly, the sort of material that will need to be disclosed will depend on the facts of the case, but it will certainly include any material that shows a fact inconsistent with the elements of the case that must be proved by the prosecution. Examples of material that might reasonably be considered to satisfy the section 3(1)(a) test will include material that raises doubt on the accuracy of prosecution evidence, material that points to any other person having involvement in the alleged offence, material going to the reliability and credibility of prosecution witnesses, material supporting any defence or explanation that has been raised or that can be anticipated, material that might bear on admissibility of evidence or leads to an abuse of process application. This could be a matter such as incomplete compliance with search warrant procedure. The categories of potentially disclosable material are really unlimited. Properly applied to the facts and information gathered in an investigation, the disclosure regime should permit proper and timely identification of material that must be disclosed. Please could you put up slide 1 again. It is usual in an investigation for a disclosure officer to be appointed. The disclosure officer must work together with other investigators, if there are any, and the prosecutor to ensure that disclosure obligations are met. It is vital that the disclosure officer has the necessary experience and competence to undertake the role. It is imperative that they record and retain all material relevant to an investigation. If in doubt as to its relevance, it should be recorded and retained. An important part of the disclosure regime is for the disclosure officer to draw up a document indicating the nature of non-sensitive unused material in the possession of the prosecution and stating that he does not believe it to be sensitive. This must be given to the prosecutor before he acts under Section 3 and to the accused at the same time as the prosecutor acts under Section 3. The non-sensitive unused material schedule is common to all who practice to any real extent in criminal enforcement. This should list all relevant material, but only that satisfying the Section 3 subsection 1a test will be disclosable to the defence. The CPIA Code of Practice, revised in March 2015, has changed the circumstances when such a document should be prepared and when disclosure of material should be made to the accused. In cases to be held in the Crown Court, a schedule of unused material should be prepared and given to the prosecutor at the same time as the prosecution file in preparation for the first court hearing. However, in the Magistrates' Court, it is different. If it is anticipated there will be a guilty plea, a schedule or what is known as a streamlined disclosure certificate is not required. Only in the event of a not guilty plea actually ensuing will the prosecutor have to act under Section 3. It goes without saying, really, that it's fundamentally important to get disclosure right. If you are a prosecutor and if you do it in accordance with the CPIA, you will not go far wrong. Err on the side of caution. The path of criminal litigation is, as many of you, if not all of you, will know, it is littered with examples where disclosure failures have led to cases being lost. Increasingly in the modern age, investigations involve the seizure of vast amounts of digital material contained on computer equipment. This applies as much in trading standards and other regulatory investigations as it does to police matters. It is important to consider initial disclosure in the context of the requirements of the CPIA. The principles of disclosure are the same, but how are they to be applied to this type of material? If you could please put up the second slide. In R against R and others, the Court of Appeal gave guidance where a vast amount of material, particularly digital material contained on computers, has been seized in an investigation. The court recognised that the duty of initial disclosure must not be rendered incapable of achievement because it would be physically impossible to read and schedule every document. Common sense had to be applied. The court set out the following guidance, which I summarise. 1. The prosecution must be in the driving seat at the stage of initial disclosure. It must adopt an appropriately resourced disclosure strategy with the proper selection of software tools and proposal of search terms to be applied. Material subject to legal professional privilege must be identified and isolated. The prosecution must explain what they are doing and what they will not be doing at this stage. Ideally, this would be in the form of a disclosure management document. The prosecution, as a second stage, must then encourage dialogue with the defence. The defence must engage and assist in the process. Thirdly, the Court of Appeal said the process should be subject to robust case management. The judge must hold the prosecution to their duty of giving initial disclosure and insisting on defence engagement. The aim is to get the case to the defence statement stage as expeditiously as possible, when further disclosure can be dealt with after the case issues are, as they should be, crystallised. Whilst flexibility in the approach to disclosure is encouraged, the principles of the CPIA must at all times be adhered to and not subverted. Having taken you through the basic but hugely important principles of the initial duty of disclosure, it's going to be over to Michael now for what happens next in the disclosure exercise, and he's also going to tell you about the treatment of sensitive material. Michael.
Well, thank you, Jonathan. Well, the next stage we're going to look at is what's been previously referred to as secondary disclosure, which typically occurs following the service of a defence statement. Secondary disclosure used to be covered by the old Section 7 of the CPIA, and that's now been repealed and replaced by Section 7A, which re-emphasises the continuing duty of disclosure. In reality, I don't think it changes very much because there's always been a continuing duty of disclosure on the prosecution, although there has been a tendency in the past to look at initial disclosure and then secondary disclosure as discrete stages which need to be complied with, and stages which can be considered completed once they have been complied with. But it's important to remember that disclosure is a continuing duty. Each time something changes in a case, that change might have an impact on what material is or is not disclosable. And so it's better to think of initial and secondary disclosure as milestones along the way during that continuing duty, which might trigger certain actions, but the process of disclosure remains a continuous one, which doesn't end until the trial does. So with that in mind, let's look at slide 3 now. Now, as we can see on slide 3, the key point here is how to deal with requests for secondary disclosure, or in reality, this request for disclosure made after the service of the defence statement, once the defence have seen the unused schedule which was served on them as part of the initial disclosure. The two issues I've chosen to focus on today are the importance of the unused schedule to the issue of secondary disclosure and the need to consider the changing nature of the case in dealing with requests made by the defence. So the first point to emphasise when looking at these two issues is the importance of making sure that the unused schedule is clear and consistent in the first place. So this is the schedule which gets served at the non-sensitive unused material at initial disclosure. Now, if items on that schedule aren't listed accurately, or different documents of the same type are referred to in different ways, you may end up leading the defence down blind alleys as they look for material which might help them. Now, of course, that's no good from the prosecution's point of view, because all these requests have to be dealt with, and that may end up resulting in going back to the original material to reassess it for disclosure all over again. It's far better if everybody understands what's being referred to in the schedule so that unnecessary or misguided applications for disclosure are avoided. Secondly, by the time the defence statement is served, you will already have gone through the unused material and made an assessment of whether or not it's disclosable during the initial disclosure stage. You shouldn't be fooled into thinking that that's the end of the matter, though. Because that assessment was made at an earlier stage, it would have been based on what, if anything, the defendant has said in interview, and the likely foreseeable defences based on the evidence and the circumstances in the case. By the time the defence statement is served, the issues would have crystallised and hopefully narrowed somewhat. In many cases, issues which may have seemed marginal previously may start to come to the fore, while previously anticipated issues may turn out to be agreed or irrelevant. And so as a result, requests for secondary disclosure should always be considered with that in mind. Just referring the defence back to the classification originally given to a piece of material in the unused schedule isn't always the appropriate course if the issue of disclosure has been affected by changing issues in the case. Now, that said, you shouldn't just comply with requests for the sake of it. There has been a tendency sometimes when disclosure requests are made simply to say, well, it's not relevant one way or the other, let's just give the defence the material. Now, if an item does not meet the test for disclosure, it shouldn't be disclosed just because you think it won't make any difference or it won't do any harm. The disclosure system is predicated on the fact that the prosecution hold all the cards in criminal litigation. They have the power to seize, retain and analyse all the material in the case. And that's why the duties on them are so onerous when it comes to disclosure. For that system to work, there has to be a trust that the review has been conducted properly. Once you start acceding to requests for secondary disclosure without good reason, that's often taken by the defence as a sign that prosecution is not confident in its review of the material and are now disclosing once prompted just to be on the safe side. In those circumstances, the defence will often wonder what else might have been miscategorised or missed by the prosecution, and further applications are likely to follow as the defence confidence in that process is undermined. So that's secondary disclosure, or the continuing duty of disclosure. Finally, we're going to look very briefly at sensitive material and how it should be dealt with. Now, I should say at this point that sensitive material is quite a large subject, and there are many quite detailed considerations to it. So with that in mind, we're going to cover a very brief look at some of the main issues, but quite often when it comes to sensitive material and public interest immunity, the cases can become quite technical and quite complicated. Now, there are often misconceptions about the sensitive schedule and how it should be used. So to begin with, let's have a look at slide 4. Now, as we can see from slide 4, the sensitive schedule is in reality just like the non-sensitive schedule. Both are used to list unused material, that is, material which is not evidence in the case, and, importantly, both require that the material on them be assessed for disclosure. The difference is that the sensitive schedule is used for a particular type of material, and sensitive material is defined in the CPIA Code of Practice as material which would give rise to a real risk of serious prejudice to an important public interest. So those are 3 elements there: real risk, serious prejudice, and important public interest. And that's quite a high bar to meet when you want to classify a particular piece of material as sensitive. And of course, neither the content of the sensitive schedule nor the schedule itself are to be shown to the defence. Now, this raises a question. What happens if an item on the sensitive schedule meets the test for disclosure? That is to say, that it assists the defence or undermines the prosecution. Now, that's where the obligation to provide disclosure under the CPIA and the obligation to keep certain material secret in the public interest start to be in tension with each other. And the solution is provided by the Public Interest Immunity Scheme, or PII. Now, some guidance on this is given in the CPS disclosure manual. Now, that states that where sensitive material requires disclosure to the accused because it satisfies the disclosure test, and secondly, it is not possible to disclose it in a way that does not compromise the public interest in question, and third, that disclosure should be withheld on public interest grounds, then the prosecutor must either seek the ruling of the court or abandon the case. Now, when seeking the ruling of the court, there are 3 types of PI application that might be made. The first type is where the application is served on the court and the accused, and the application specifies the nature of the material to which the application relates. The second type of application is where the prosecutor believes that to reveal the nature of the material to which the application relates would be effectively disclosing the information to the accused. In that case, the application is served on the court and the accused, but the nature of the material is not disclosed. The third type is where the prosecutor believes that to reveal to the accused that an application is even being made at all would effectively disclose the information. In this case, the application is served on the court, but not on the accused, so it's effectively being made without notice. And those will be quite rare cases. Now, in considering any application, the court will apply the principles in the House of Lords case of H&C, effectively balancing the need to withhold disclosure to protect the public interest in question with the need to ensure that the defendant has a right to a fair trial by way of receiving disclosure. There's a 7-stage test with quite detailed principles that case sets out. Now, when dealing with sensitive material, potentially sensitive material, you should always consider whether the test for sensitivity is met and what is the public interest which requires protection. There has to be an identifiable public interest you can point to, such as the need to protect informants or the need to protect the location observation posts. But there has to be a public interest which you can specify and you can point to in the application. Now, it may be in some cases that while a document itself is sensitive, the disclosable part of it is actually not. and disclosure can properly be made by disclosing a redacted version of the document, providing summaries or gists, or using other similar measures, which will protect the relevant public interest that's under threat, while also allowing you to comply with your obligations to the defendant. And in those cases, the newly desensitized document, whatever it may be, can simply be included on the non-sensitive schedule instead, and the issues of sensitivity and PII can potentially be avoided. John.
Well, thank you very much, Michael, for that. Very interesting. We've covered a few key points today, but disclosure is a big topic with a lot to consider. At slide 5, which I'd asked to be put up now, please, we've set out some of the key legislation and guidance that should help you carrying out your duties regarding disclosure. One that we omitted to put on that when we were preparing the slides, which is also a very important document for you to consider, which many of you will know about already, is the Code of Practice that made under the Criminal Procedure and Investigations Act 1996. Made under the Act itself is a statutory code. It's a useful document, so please also bear that in mind. And of course, we at Gough Square are always on hand if you require some further training on this matter or advice on specific issues.
Well, that brings today's talk to a close. We're going to have a look at any questions which you've sent in. We have 2 here already. So, Jonathan, I'm going to throw these ones over to you.
Right,
First of all, some local authorities have taken the view that they need to obtain and provide the court with PNC checks of all witnesses to fulfil their disclosure requirements. Does this have any basis in law, we're asked?
Well, I think that's a very interesting question, because I think that until a recent case, which actually was some 5 years ago, I think it has simply been assumed that the previous convictions of a prosecution were disclosable under Section 3. But there's a Privy Council case which I dug out. It's actually in Archbold in the main criminal texts, which says that that in HM Advocate against Murder, Privy Council said, deciding under the Scottish non-statutory disclosure regime, only details of a witness's criminal history which might materially weaken the Crown case or strengthen the case for the defence had to be disclosed. And the disclosure of a previous conviction of a witness which might harm his reputation without regard to materiality would not be justifiable under Article 8.2 of the European Convention on Human Rights, which is privacy. But that those principles are equally applicable to disclosure under Section 3. So it would come back to materiality and looking at the context of the case, I suppose, in terms of whether you would disclose the previous convictions of a witness to the defence. And I'd be interested to hear your views on it, Mike, but it seems to me that in an orthodox case, you will often get hold of the previous convictions of witnesses in a case during your investigation. But that doesn't mean you have to disclose them.
Yeah, I think like many things when it comes to disclosure, it's going to be a balancing act, isn't it?
Yes.
Because it may well be the case that there are cases where credibility of a witness is simply not going to be an issue. There are, particularly in regulatory offences, with many strict liability offences, credibility doesn't really come into it. And so it's one of those things, again, which you may also need to keep under review, because at the very early stages of the case, it's clearly going to be potentially
Yes.
a reasonable line of inquiry for you to obtain the material. As the issues crystallise, though, it may be that those issues fall away somewhat. So I think, Jonathan, you're right there.
Yeah.
You may well, and you probably in most cases will obtain them, but whether they become disclosable in due course is going to depend on the issues of the case
Yes.
and how it develops.
So I think that answers the question, because I think that the person who asked that question, which is a very good one, wanted some steer on the basis in law for it, and I hope that we've given some assistance on that particular issue.
Yes. Question number 2 is deals with a situation where a defendant's legal team requests disclosure of the disciplinary records of all of the officers involved in the case, but the prosecution doesn't think they have a basis to believe that anything adverse exists in those records. The question is, isn't that just a fishing exercise rather than a proper application of the disclosure rules? What do you think?
Sounds like a fishing exercise to me, Michael. I mean, if an officer does have a disciplinary record which bears on any issue in the case, then of course that is relevant to the investigation and may be disclosable if it's pertinent to an issue in the case, and it's something that the investigator and the disclosure officer ought to know about. But that's a long way from saying it's disclosable. Of course, it is a fishing expedition just to ask if they've got any. I don't think you'd have to answer that request. It might be that they haven't. If there aren't any disciplinary records pertaining to officers, it's a non-issue. I think you can just say no. But any views on that, Michael?
I think again, if it's probably material which you may well have obtained at an early stage, if it looks like it may be an issue. But like the PNC issue, I think it needs to be looked at in the context of the issues in the case. Clearly, if you're talking about a search that's been undertaken and some kind of allegation of interference with any of the evidence that was seized or anything like that, then the officer's previous disciplinary findings are going to be quite important. But if the issues don't go anywhere near that, and this sounds like the sort of request made after a defence statement where the issues should really have been crystallised. If those issues don't really touch on anything that's been put in issue in the defence statement, it may well be that they're simply not relevant. And of course, it's always open to a prosecuting authority to go back to the defence and say, well, we are prepared to potentially disclose this to you if it turns out to be relevant, but we don't see how at the moment it affects the case. Could you provide us with some clarification as to why you want or need it? That will either provide a justification for it, or it may well simply confirm the view that they're simply trying to go on a fishing exercise and find as many documents as they can.
And it comes back to, I think, when you look at the whole regime, you apply the test to the facts, analysing the state of the case at the time, what you know, what the issues appear to be. And I think that will help you in coming to a decision whether a disciplinary record is actually disclosable.
Yeah. We've got a third question which has just come through on the live chat from Hagimu2. Are case decision documents disclosable? So I think by this, what we're referring to, and feel free to correct me on the live chat if I'm wrong, are things like the prosecutor's report, setting up the facts of the case and the legal view on whether or not to prosecute and what for.
Well, they're not prima facie disclosable. I don't think. I think they might potentially become disclosable if the case for disclosure is met under section 3(1)(a).
Yeah. There is guidance. I think it may be in the AG's guidance that documents like that prima facie are not actually considered unused material, and so if they're not unused material to begin with, they're outside of the scope of the disclosure regime in general. However, that can be overridden if there is something in them which becomes plainly disclosable. So if, for example, in those documents some kind of comment is noted that displays some sort of bias or shows that prosecution is being pursued in bad faith, that rule can be overridden. But as a general rule, to begin with, internal communications like that don't generally get considered to be unused material per se.
Yes, I agree with that. And where I've seen them in my own experience has been in abuse of process type applications, bias applications, where there has been some material contained in such documents which might be thought to have a bearing on the issue in the case, and they've been disclosed, and I've had that happen on both sides. But prima facie, no, you wouldn't be volunteering it, or
no, certainly. Absolutely. Well, I think those are the questions we've had through this morning. So that brings today's talk to a close. Thank you all for tuning in. We hope you found it useful. As always, if you have any follow-up questions or feedback by email after the session, those are always welcome. And our next broadcast will be Fred Philpott and Kate Urell, who will be discussing advertising standards regulation. and the details for that will be sent out in due course to you all.
Are we hoping that's on the 1st of February?
It's expected to be in early February, date to be confirmed at the moment though.
Right, okay, thank you.
So we hope that you'll all be able to join us again on the next occasion. But for now, from me and for Jonathan, thank you for watching and goodbye.
Goodbye.